The Supreme Court validated the 2016 demonetization decision of the Modi government, rejecting all pleas challenging note ban. In a 4-1 majority judgment, the top court said that the centre had the power to demonetize all series of banknotes, adding that the decision can't be said to be unreasonable. While the BJP is hailing the verdict, the Congress says this is a slap on the wrist of the government. Here's a report.
रात्रि को 12 बजे से वर्तमान में जारी 500 रुपए और 1000 रुपए के करेंसी नोट लीगल टेंडर नहीं रहेंगे।
6 years after the Narendra Modi government demonetized 501,000 notes in one stroke, the decision has got a stamp of approval from the highest court of the country.
Does not suffer from any flaws in the decision-making process.
A 5-judge bench of Justices Abdul Nazeer, B.R. Gavai, A.S. Bopanna, V. Ramasubramanian and BV Nagarathna on Monday delivered a 4:1 verdict upholding the validity of process followed in demonetization.
Despite the case of proportionality and as such cannot be struck down.
Justice B.R. Gavai, giving the majority judgment, said the decision-making process cannot be flawed only because process emanated from the government. The court said there was consultation between government and the RBI for 6 months. The verdict said there was reasonable nexus between measures and objective to bring demonetization. The court added that it's not relevant if the objective sought is achieved or not. The SC said the 52-day window given to exchange the notes cannot be called unreasonable.
The period provided for exchange of notes by the impugn notification dated 8 November 2016 cannot be said to be unreasonable.
The Supreme Court has categorically held that it is not relevant as to whether or not the objective is achieved. But what is important is that there is a reasonable nexus between the objective and anything that is sought to be achieved.
By way of debate, I say
the only woman on the bench was also the sole dissenting judge on the issue. Justice BV Nagarathna said if demonetization is initiated by the centre, then it can only be by means of an ordinance or parliamentary legislation. The judge said under the RBI Act, the recommendation has to be initiated by the RBI. But here, according to the judge, it was the government that initiated the move. Justice Nagarathna said it's beyond doubt that such a measure by the centre was well-intentioned.
Not under section 26(2) of the Act. It is to be by way of a legislation, and if legislation is not the way, in the sense there is need for secrecy, then it is ordinance.
With 4 out of 5 judges deciding in favor of the demonetization policy, Centre's 2016 decision, which has been one of the most controversial economic decisions taken in this country, now stands upheld. With camera person Ashwini from New Delhi, this is Srishti Ojha, India Today.